The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
A former fire chief claims his wife had a seizure, and initially the paramedics believed him. Why he's now on trial in Washington for murder. And in New York, Luigi Manion back in court as the attorneys debate death. Also in the Big Apple, our guests give their takes on the presidential response to Sean Diddy Combs' pardon request. In the court of law, everything is done for the day in those cases. Let's call to order Court of Opinion. Welcome to Court of Opinion. I'm Julia Jenaé. Thank you for joining us this evening. Was it seizure or strangulation? That's the question a jury in Washington faces in the trial against a former fire battalion chief. He's accused of killing his wife in what prosecutors are calling a crime fueled by betrayal. Former fire chief Kevin West is charged with murdering his wife, Marcy. He called 911 in January of 2024. He claimed his wife, Marcy, was having a seizure, and first responders rushed in to save her, but they couldn't. Months later, a medical examiner looked closer and found injuries on her body that were consistent with strangulation. Then Marcy's death was ruled a homicide caused by blunt neck trauma. Meanwhile, an investigation also revealed something else, that fire chief was having an affair and that he planned to move out of his home with Marcy the same day that she died. The court has restrictions, so we can't air that testimony until the day after. So let's get you caught up on what happened in that trial yesterday.
Getting to the actual involvement that you had on January 8th, 2024, did you respond to the West residents on that day?
I did.
Based on your training, education, and experience, would anything that was done during the resuscitation efforts on Marcy West would have caused a hemorrhage to her esophagus?
Nothing that I observed.
Would anything done during the resuscitation efforts have caused a contusion on the back of Marcy's head?
Not that I observed.
Would anything done during the resuscitation efforts of Marcy have caused bilateral bruising behind her ears?
Not that I observed.
Were there any remedial measures that were taken as a result of this call or additional training that needed to happen?
No.
Was there anything unusual noted about the care on scene with Marcy West?
No.
Did you notice urine on the bed?
I noticed the liquid on the bed, yes.
Tell us what you noticed as far as liquid on the bed.
There was liquid on the bed where I would assume if someone urinated the bed, it would be.
And now, could that be consistent with a seizure?
Yes.
And it could also be consistent with other things.
Sure.
What was Kevin's demeanor like when you talked to him on January 8th, 2024, when he brought over the casseroles?
I don't recall him being anything out of the ordinary, I suppose.
Did he say anything to you during that conversation about Marcy's belongings?
He expressed if I thought it was okay that he would start to get rid of Marcy's belongings.
And did you ask him about Marcy's belongings?
I did not.
Was that statement he made to you unprompted?
Yes.
Did he talk to you about the autopsy results at all that day?
He expressed to me that an autopsy doesn't always come back with a cause of death.
Did you ask him a question that would have prompted that discussion?
No.
Did you enter the home of Mr. West?
We did.
And did you inform Mr. West that you were equipped with body-worn camera?
I did.
I know this might be difficult. Are you able to talk us through kind of what happened or when it first happened?
Yeah. So my dog was whimpering, and I woke up and then realized she was having a seizure.
Okay.
So I went around the bed. She was close to that end table to the right of the bed.
Okay.
I slid her down just a little bit, I rested her on my knee, and helped her to the floor. I got her on her side, And then I ran around the bed, got my phone, called 911. She stopped seizing, and I was on the phone with dispatch, had on speaker, phone's right in front of me, and she wasn't breathing. So I started CPR. The guys came in and took over.
Okay.
Yeah.
And then as far as like symptoms of the seizure, are you able to describe like what she was experiencing?
Very stiff and locked up.
That trial for Kevin West, it is still ongoing, so we're going to talk about it. It's a new one here on Court TV. Let's bring in our fantastic guest panel that we have on Court of Opinion tonight. Joining us in the studio, we have criminal defense attorney and former prosecutor Marie Pereira, and trial attorney and former president of the National Bar Association, C.K. Hoffler, is here in studio as well. And joining us remotely, criminal defense attorney and former head of New Jersey County, prosecutor Bob Bianchi. It's great to see all of you. Thank you for being with us here on Court of Opinion. And we're going to get your opinion on this one, because this one involves a fire chief who's accused of killing his wife. He says it was a seizure, but the prosecution says something totally different. CK, I'm going to start with you. What's your opinion on this case?
I mean, I just don't know why people think that when you strangled someone and there's going to be physical evidence that you can talk about a seizure. I mean, obviously, and then you have a little girlfriend on the side, you know, that you get engaged to after. All of that just reeks, it smells. So why, when you're planning this, and that's everybody's innocent until proven guilty, but why would you not believe that the physical evidence would not manifest itself?
He tried to say that his son was giving mom a massage, and
Crazy.
it was like a strangulation massage.
Crazy.
That's
See,
how she got the bruise on her neck and behind her earlobes.
So, Julia, blame the son. This is the old blame the son thing. You see, all of this is, to me, ridiculous, where he thought he could actually get away with this.
Bob Bianchi, let me get you to jump in with your opinion on this case against a former fire chief, though. He's got some respect in his local community.
Yeah, I happen to have a unique perspective as a former homicide prosecutor and as an EMT who goes on these calls.
All right, okay.
So I recently handled a case like this, and I'm very careful not to jump to conclusions when people are lying, because people lie for all sorts of reasons, like hiding an extramarital affair. This case is going to come down to the medical examiner, and I would agree with the ladies here that when you're talking about the wounds behind the ears, they're called battle signs.
Yes.
It's something we look at with somebody who has suffered severe trauma, and that bilateral trauma says a lot to me as an EMT and as a homicide prosecutor, that this was not something that was done as a result of resuscitative efforts. Now, listen, resuscitation is a violent experience. I just had a call the other day. CPR is not for the genteel. There's a lot of movement, body mechanisms, but not in the back of the head. And more importantly, I'm sure from the medical examiner, we're going to be hearing that the petechia, or broken blood vessels, as well as tissue damage to the neck and to the muscle, would not be a result of resuscitative efforts. Last point, that's why the prosecutor was doing what we call pertinent negatives and saying, you didn't do anything that would have caused these injuries, in order to remove that defense argument.
Well, let's talk more about the injuries. I'm actually going to play something that the prosecution said about these injuries, because there's even one to the esophagus that's included. This was from the prosecution's opening statement about Marcy's injuries.
Dr. Burt will testify that there was damage to the carotid sheath that covers your carotid arteries. There was damage hemorrhaging to the esophagus. There was bilateral bruising behind the ears. And that when the scalp was peeled back, there was a large contusion between the skull and the scalp.
You know, initially, CK, her scalp was not pulled back. Initially, this was ruled natural causes before the second look by the medical examiner.
And these are definitely not injuries that you can get from having a seizure. If you fell when you had a seizure, all right, maybe the contusion to the back of the head.
Or a massage. I mean, what are we talking about?
Come on.
You know, you see, that he must have thought, because maybe he was a fire chief,
Exactly.
and he had all of this experience and this
Exactly.
and that and that and this. You know, Julie, maybe he thought that nobody would notice, and he was ever so careful. That's what I believe he was thinking, that he was believing, he was drinking his own Kool-Aid. But I'm just telling you, I mean, these types of injuries do not result from, A, any massage, blame it on your son. The son, he did something to massage. What kind of massage is that?
Well, a strangulation massage.
You're massaging your mother to almost strangle and kill her.
All right, I see Bob Bianchi's lips moving. I hope his mic is working. Go ahead.
It's
You're
hard.
trying to jump in. I see you. Go ahead.
Okay, thank you. Yeah, listen, guys, I do want to say, though, it is not uncommon that people who are seizing create injury to themselves. The number one thing you do during a seizure...
No, they bite their tongue.
Let me finish the sentence.
They aspirate. They don't have blunt injury to the neck.
That's not the only injuries you get in a seizure. But wait a minute.
All right, let our remote guest talk.
That's a comma. That's a comma. I didn't finish the sentence. However... That said, they're going to show that those kind of injuries that you would get would typically be cranial injuries that would be superficial wounds on the outside of the body, not the inside. So thank you for letting me complete that thought. Second point is this. Many times, a lot of people don't get this, and they get it wrong. I've been on homicide scenes. I've watched these investigations, and they'd probably be shocked that so many cases that turned out to be murders were initially declared medical events, suicide, and something other than nefarious. And because of good investigations and a look back, it turned out that it was a murder case. So this is not unusual.
Let's play something that the prosecution brought up that I thought was very compelling evidence. It's a letter that this defendant wrote. So this affair, that's something that has come out, and that is one of the reasons that they looked at him for this murder. They say that he was wanting to move out of his house with this woman, and he wrote a letter not to her, but to her mother right after his wife died.
On January 7th, the day before Marcy's death, he texted his mistress's mother. Just felt the need to send you a message. Today has been a tough day. I keep thinking about how happy I was yesterday and how we laughed. I want you to know how spiritually connected Cynthia and I are. We have something so incredibly special. Yesterday, talking with you, her, and I together felt so great. I can't explain the familiarity and love I have for both of you. You're my family, and I feel like we have always been. Thank you for your love and support.
This feels like a soulmate situation almost, ladies. What do you think about that letter as evidence, or text message, but essentially it was a lengthy one?
I think it's very compelling because it speaks to, see, he didn't get his story straight when he was aligning this. I believe, obviously I believe he's guilty, but he's innocent until proven guilty. And having that kind of letter, that type of text, and the intimacy of it speaks volumes, I believe, and contradicts what he was saying. Now, a lot of people do lie about having affairs. Bob said that, true. We understand that, but you gotta know. You're a fire chief, you gotta know. You can never erase text messages. You can never, there's always going to be something found where you said something, and he had to have known that that was going to be found.
It was a handwritten letter, though, right?
Oh, no. This was actually a text message.
A long text message to the mother of the sneaky link side piece. Let's stop calling her mistress, a paramour. That's too deep and respectful. She was a side piece for 20 years. I remember her name, Cynthia Ward, stuck in my head. And he was a married man. And for him to be writing letters to her saying 2024, baby, it's gonna be a pop-out year, go away with that. That is serious, serious motive.
And texting her mother.
Oh,
you see,
God.
this is what is, this is.
And Bob, this is the type of evidence that not only is compelling, but it is that lying that this defendant did. His defense has had to own that. But they are standing on the medical evidence in this case.
You got two things that come to mind with this. The first is, like the ladies are saying, goes to motive. The second thing is it's going to be perceived from an emotional and visceral perspective very poorly by the jury that's judging this man. And then the last point's a little kitschy, but it's so true. If it weren't for stupidity, none of us would have jobs. Defense lawyers, prosecutors, judges, or even us right now on court TV.
Say it loud, brother. Yes.
If it's a coincidence, that's what the jurors would have to find in order to find him not guilty. Everyone stand by. We've got to get to another case. When we come back from this break, we're going to take a closer look at the evidence presented to the jury today in the Uvalde school massacre trial, the most graphic representation so far in the horrific events that were carried out that day. But does it point to negligence, criminal negligence by the defendant?
The Court TV podcast will return.
I was just telling him to pray. I told him I loved them. And I just kept saying, like babies, I love you. Just pray, I love you. Okay. I wanted to tell them it would be okay, but I wasn't sure, and I just wanted the last thing they heard was that somebody loved them. So I think I said it 1,000,000 times. I just kept saying, I love you.
In Texas, jurors have listened to heartbreaking testimony like this from this school teacher who took the stand for week 1 of a trial for a former Uvalde, Texas school police officer who's accused of not doing more to save lives in that 2022 massacre. The victims include 19 students and 2 teachers who were killed. And on scene, there were nearly 400 officers that eventually arrived that day, but Adrian Gonzalez was the first. And the former Uvalde school police chief has also been charged, Pete Arredondo. It's Adrian Gonzalez's case that's going forward first. The allegations say that Gonzalez didn't go towards the gunfire despite hearing shots and being told the shooter's location. The evidence presented in the trial so far has given these jurors a detailed look at the horror that was carried out that day on May of 2022. But we've been asking, how does that carnage get used in court when the shooter is not the one who's on trial and he is not the one who even manned the team that killed the gunman eventually? Let's see what our court of opinion team chose as today's best physical evidence inside of the courtroom. Here it is. Crime scene photos of the classrooms shows bullet holes through the windows and bullet holes in the ceilings. This is something that we have seen several angles of. And this one in particular, you're seeing the shattered glass. You're seeing the damage to the building. The reason we're showing you the damage to the building is because the damage done to those bodies, the damage done to those children, to those teachers, that's something that's not permitted to be shown on TV, shown to people in the courtroom outside of the jurors. But even seeing what damage was done to this building tells you how horrific this was inside. Let's bring in our power panel who is standing by to talk about this difficult case, but one that's important to our legal system. We have Marie Pereira, C.K. Hoffler, and Bob Bianchi in studio and remote with us. Bob, I'm going to start out there with you. We've talked about this case, I don't think on Court of Opinion. This is my first time getting your opinion on this one. But when we're seeing the damage inside of that room, these jurors are taking note of just how horrific this was, even though the gunman isn't there.
And you know what? It was horrific to any first responder who went there, especially a guy who has no idea, no backup, no additional firepower, no information specifically as to how many shooters there are, where the shooting specifically is coming from, and when their life is in danger. Now, I know I'm going to take a contrary opinion here to most people. What happened is an absolute tragedy, but I would be, as a defense lawyer or as a prosecutor, let me put it that way, worried about the defense lawyer who says, where are the rest of the people? The 77 minutes that it took when they had all the personnel, all the firepower. They knew they were only dealing with one suspect in one specific location. None of those people are sitting here, just the first guy who shows up like hot potato. Listen, I think that it's easy to sit in a courtroom, pull out photographs, go through every nanosecond of what went on, and second guess somebody who was dealing with a fearful situation. Last point, nothing in tactical operations requires that you run into a buzzsaw, because you being dead is not going to help anybody. So I'm just wondering, I'm just saying.
This is a prosecution to appease. That's what it is. It's prosecution to appease. You're absolutely right. Why him? Because somebody has to pay for what happened, and why not it be him? That's what happened with Nicholas Cruz, and they tried to get that guy too, and they acquitted him. Somebody has to pay.
And I want to make sure, when you said they, of course, got the shooter in Parkland, and it was the officer, Scott Peterson,
the SRO,
who stood trial and was acquitted. Your opinion on this evidence, CK?
You know, I think this evidence is very compelling. You know, you don't, because if you're a jury, you're looking at, you're envisioning how devastating it must be. And they're going to actually see what we can't see. So I think this is very, very compelling evidence.
Let me ask you this, is it compelling towards felony child endangerment, or compelling to show the atrocity that happened? right?
Towards felony child endangerment. Why? People want justice somewhere. He's the first one on the scene. Yeah, we don't expect him to run into the situation that way. And, you know, again, but we do expect that he would do more than he did.
Yeah,
so there is an
See,
expectation.
this is the thing.
No one said
this is the thing that never ceases to amaze me.
know, but 77 minutes. Oh my goodness.
But he wasn't the only one.
He wasn't the only one. But he was the first one. But he was the first one. He was the first one. And you see,
I need a gavel. Let's let Bob jump in, and then I have a second piece of evidence that I want to get to. Bob, really quick, and I want to get to my second evidence.
Yeah, but this all goes, listen, I was a prosecutor. I used to make the calls, and I got to stand back from the court of public opinion and not let the tail wag the dog. It's about justice here. And the breakdown was in training and in the incident command structure. They can't have it both ways where they're charging Abadando, or whatever his name is, for improper incident command and then sacrificing the person that was part of that command that didn't run in there in 3 minutes. No way.
All right, let's get to our second piece of evidence that our court of opinion team put up. This is a state exhibit, and it was showing the police cars line of sight at Robb Elementary School. So the witness on the stand who actually let us see this is witness Ranger Kevin Wright. He confirmed that the school building and the playground were in the line of sight to the police cars on the campus. This is where everything went in. Let's take a listen to some of that testimony.
Is there a building behind that first vehicle that you pointed to?
Building right here behind this patrol car.
Is that in the line of sight?
Yes.
And to the right of that, been described as a playground.
Over here?
Yes. Is that in the line of sight?
From this area?
Yes.
Yes.
All right, so we've got here, this one I think could, Marie, actually be more to the defense, or to what the defense is here going against it for the state. They're saying he would have known, and the police who were outside would have known where this gunman was and where the gunman was going.
There is still the option for him to use his training and experience and look at the totality of the circumstances. We can't say he did right or he did wrong. He did his job. The outcome was tragic. We all know what happened. But to say that he's 100% responsible because he didn't shoot down the shooter before he went inside the school, is that what they're saying? Because he was the first one to see him, so he had to shoot him? What are they saying?
That he's 100% responsible, but he bears responsibility. And you know, when you're deciding who you go against whoever the best evidence that you have, the most evidence, the most compelling evidence, who is most culpable looking, because you want a victory in a case like this. And
you want justice, not victory.
Well, victory, justice equals victory. Justice equals victory. Justice equals victory.
That's not true.
No.
When I say just for these, because
this is prosecution to appease is what it is. And since we were doing
said it doesn't equal justice,
prosecution to appease.
Let's give Bob the last word in this one. He can't jump in as easily because he's remote, so I have to help.
I know, this is an unfair fight.
It is.
This concept that justice is victory is a very dangerous statement to make, because as a prosecutor, I could have won, maybe tried cases that weren't the right thing to do. Victory doesn't necessarily mean you're achieving justice. And in this particular case, if it's simply to appease the court of public opinion, then in my mind, that prosecutor, whether he wins or loses, or she wins or loses, is abdicating their responsibility in a case like this. This poor guy came in there in very difficult circumstances, and everyone's second-guessing what he did. Where is everyone else that sat there for 77 minutes? Where are they?
Yeah, but I'm not saying he's the only one who's culpable, who's guilty.
He's the only one sitting there. Well, I don't see nobody else there.
All right, that's where we have to leave it. I hate to cut everyone off. We've got to go to our break, but this just shows how difficult a case like this is, and it's going to be difficult for a jury. That jury's coming back on Monday with more testimony. Court TV will be covering it. When we come back, we're going beyond the gavel, breaking down the biggest true crime cases, and this one is a big one. Accused CEO killer Luigi Manion. He's fighting the death penalty and could even stand trial before the end of the year. Let's talk about it on the other side. Stay with us. You're watching Court of Opinion.
Now, back to the Court TV podcast.
Let's go beyond the gavel. In New York, Luigi Manion was back in court today, where we learned that he could stand trial before the end of the year. His attorneys continue to fight for the 27-year-old accused killer to avoid the death penalty being on the table in the fatal shootings of United Healthcare's top executive back in 2024. Manion's lawyers contend that authorities prejudiced his case by turning his arrest into a, quote, Marvel movie spectacle, and by publicly declaring their desire to see him executed even before he was formally indicted. Now, here's just a look at some of the facts in this case. No death penalty in New York State. Federal prosecutors are the ones who brought additional charges, and they are seeking the death penalty. Now, he still faces those state charges in New York for the death of Brian Thompson. The judge expects Manion's trial to begin in December or January of 2027 with testimony. That's if the death penalty is on the table. If the death penalty gets taken off by the judge, then it could begin as early as October. Either way, jury selection is going to start on September 8th. Now, Scripps News Group's Alex Miller, she has been following this case, and she was at today's hearing and has the latest developments from New York.
Luigi Manion making his first federal appearance since April 2025. Manion brought into the courtroom in a tan jumpsuit, unshackled at the hands, but shackled at his feet. He was calm as he spoke with his attorneys as the judge prepared to hear arguments that could result in a life or death decision for him. Manion's team is specifically focused on the federal charges 3 and 4, one of which is a murder charge that could carry the death penalty. They say the arguments behind the charge are legally flawed. The discussion between the attorneys, including a special attorney Manion's team hired to argue this case, was in the weeds, at times discussing stalking and intent and whether they amount to a violent crime. Prosecutors allege Manion stalked United Healthcare CEO Brian Thompson in person and online before killing him. The defense is also aiming to have evidence, including Manion's backpack and its contents, thrown out. The judge declined to assign a trial date, saying that she had too many motions to consider that could have other implications. Alex Miller, Scripps News Group, New York.
The judge also said she would rule at a later date on the defense's request to prevent prosecutors from seeking the death penalty, throw out some of the charges, and exclude certain evidence. We will see what happens, but right now, capital punishment still on the table. So let's talk about it with our power panel. Joining me in studio tonight, we have Marie Pereira and C.K. Hoffler, and joining us remotely, Bob Bianchi is with us. C.K., let me start with you. Your opinion on the death penalty being on the table, federal prosecutors adding charges after we saw those state charges in New York. Then the feds came in and said, we want death.
So I think this case and the federal charges, adding the death penalty, I think that's all politically motivated, quite frankly. And that's just the reality. I mean, when you've got the head of the Justice Department making a statement, speaking about this, and then, you know, and then their death penalty, the death penalty brought the federal charges. Now, they can do that, of course, but it's politically motivated in a state like New York. Think of the politics right now in New York. So I think we cannot ignore the politics. I'm not saying it's right or it's wrong. I'm saying there's a political component to this case that we simply can't ignore.
Got a resident New Yorker in Marie Pereira here. What do you think about the death penalty on the table?
I don't think it's political. I think he murdered somebody. He stalked a man in the middle of the day. He showed up behind him and he shot him dead. The guy had family. He didn't do anything to him. He didn't even have a chance to fight because he shot him from the back. I mean, it's sending a message. You cannot do that in our society. Stalk people for no reason. He had no reason except he didn't like the guy's policies as it related to insurance, to an insurance company. So let's just find who we don't like, buy a gun, and stalk them and shoot them down. All the aggravating factors are there. That boy, and then he's smiling on the camera and cheesing like he's some superstar.
So he'll get to, no one's saying he's innocent. I'm not saying he's innocent. I'm saying there's a political issue.
Should he be
when you
a
have the head
candidate for
of
the death penalty?
Yes. Who's making comments and statements? Is she making statements about every case? What are we talking about here?
Bob, your opinion. Go ahead.
Look, guys, this is about prosecutorial mathematics. The more you throw on with multiple jurisdictions and the more outcome there is, and you turn into a death penalty, ratchets up the exposure of the defendant. And when you're doing death penalty litigation, which I've done, the mantra is keep them alive for another day, another week, another hour, another minute. So what's happening here is they're adding that pressure. Now, here's the issue. I've said this from the beginning of this case, having been in the middle of interjurisdictional prosecutions.
Yeah.
Number one, the search and seizure issue, unforced error, giving the defense opportunities to take shots at the defense's, at the prosecution's case. Number two, the perp walk. A classic example of egos gone awry in law enforcement, and now you have made this guy a national hero because of it. And last is the tug of war that's going to go on in the egos between the federal and the state jurisdictions, where they're going to be fighting over who's prosecuting, when they're prosecuting, what evidence, who has access to the evidence. If they don't watch it, they're going to fall into a trap. Although ultimately, given the evidence, given the exposure between both jurisdictions, they're adding it all on, they're piling on. He's going down.
All right, I want to get to jury selection, what we think these jurors are going to be thinking. Let's listen, though, to Luigi Manion's attorney, one of the few times that she's spoken publicly about this case, and it was to condemn some of the things she says the prosecution and other governmental figures have said about the case.
What I did not understand was how shocking it was that this week on HBO, in a documentary, I see the chief of detectives and the New York City mayor, full hair and makeup done, sitting down and giving an interview for television and talking about the evidence in Luigi's case, talking about police paperwork that we don't have, talking about forensics that we have not yet received. I guess we have now today, but I didn't when I was sitting there learning about the case, hearing an actor play Luigi reading from a journal that they say is Luigi's, and we have yet to receive it from the prosecution.
That was from back in February of last year. CK, what's your opinion on whether or not jurors are going to be able to set aside everything that we have seen? I mean, she's talking about HBO, but the reason it immediately went to HBO was because this was a national manhunt that just grabbed headlines.
I think the jurors are going to have a very, very difficult time, Julia, setting aside all of that information. But they're going to find some jurors who won't find it to be too prejudicial. They're going to have to, because think of it, especially in New York, there are other cases that have had the same type of sensationalism, and they've been able to find jurors of their peers that have either acquitted or convicted. So they'll be able to find the jurors, but it's going to be very tough. I'm saying let the evidence, let it do what it's going to do. All this, you know, ego, power struggle, federal, state, that's only going to benefit the defendant, in my impression.
Oh yeah, federal's going first, it seems, not state. How do you feel about that?
Well, since federal is trying to bring the death penalty, I would be for that, because I believe the death penalty should be an appropriate punishment if he's convicted for this, because what he did was wrong on all levels, and we can't endorse that in society. He may have a bunch of little girls treating him like he's a pop criminal murder star, whatever he wants to call himself, but what he did was wrong. And he deserves to face the death penalty if he's convicted by a jury of his peers.
Okay,
he
of
needs
course,
to have that on the table.
Disputing that what he did is wrong. No one is disputing that he probably will be convicted. But I'm just not one who's in favor of the death penalty.
Bob, go ahead.
This is political.
In a case like this, I think it is appropriate.
Just because then we got to just look at the entire system.
I may be the only person that's ever prosecuted a death penalty case on this panel, and I can tell you that I'm against the death penalty. And why? Because of ego and the things that the defense lawyer brought out in that discussion about how it's about hair and makeup. It's these issues that cause people to be, some people to be executed or sentenced to death, and other people not. And that randomness bothers me. Last point I got to make here, guys, as lawyers, we have to agree.
In this
as
case.
a prosecutor, I would never allow my law enforcement officers to be speaking publicly about a case.
I agree with that.
We all agree.
And there should be some type of
we have a duty as
in
prosecutors. We have a duty as prosecutors not to try cases in the court of public opinion.
I agree with
and there
that.
should be a penalty for that. Those are extrajudicial statements that are inappropriate.
I think that is a
agree
great
with that.
note to end on. We actually have all of our panelists agreeing on something, that you don't try it in the court of media. Let's get to our break. When we come back, though, we've got hot takes and cold facts. Our panel's going to give us their opinions on today's biggest cases, including these. A movie mogul considering a guilty plea ahead of his third sex assault trial, while a music mogul tries to get a presidential pardon. All of it ahead.
This is the Court TV Podcast.
Welcome back to Court of Opinion. We're now getting to our hot takes on cold facts and the trials that we bring you here on Court TV. This is on the big legal headlines that have been developing today, and we're going to give our guests 25 seconds on the clock to state their case because we want to get to all of them and all of these stories. Here's the first one. The movie mogul convicted of sexual assault on two coasts may be considering a plea after Harvey Weinstein's 2020 New York sex abuse conviction was overturned. A retrial last year ended with the jury hung on a rape charge. A retrial for New York may begin in the spring. Now, defense attorneys have 2 weeks to tell prosecutors if he is planning to plead guilty to that charge. Now, Weinstein admits he was unfaithful, but insists he never assaulted anyone. He also still has a California guilty verdict that still stands. He's 73 years old. Let's bring back in our power panel. We have with us Marie Pereira, C.K. Hoffler, and Bob Bianchi. Marie, I'm going to start with you on this one. 25 seconds on the clock. Should he take a guilty plea in this case?
If he's claiming his innocence, how is he going to take a plea? In order for you to take a plea, you have to really say, I did what you said I did, and in return for me coming clean about it, I'm going to get this sentence. If he's still claiming I might have been an adulterer, but I wasn't a rapist, it's a problem. He may take the plea. Sometimes people take pleas and they lie about what they didn't do or did do, but, you know, he's sick, he's old. Maybe he will, but if he's still out here saying, I didn't do it, how is that going to work out, taking a plea?
Bob Bianchi, what's your take? His defense says if there's no prison time involved, he may plead.
Yeah, this is a really difficult calculation. And again, we're back to prosecutorial and defense mathematics here. He's 73 years old. He's very ill. He's going to be serving 13 years at least on the sentence that he got in California. So the defense is going to say, look, you take a deal. If it either runs concurrent, you don't do any additional jail time. Maybe if you stay healthy, you get out. Otherwise, as a defense lawyer, I tell the prosecutor, I'm going to go to trial. I might as well do it because it's a life sentence anyway.
Yeah, CK, I sat through the first trial in 2020 in New York, and the jury found him guilty on most of the charges. This is 6 years removed. What do you think a jury will do with it this time around?
I think they'll find him guilty. I think the evidence is going to be there, and they're going to find him guilty, Julia. I mean, I just think it's just that simple. So, plea, no plea, some plea, he's going down for this, in my impression.
All right, that's your take. Let's move to the second story in our list today. The families of 4 University of Idaho students who were killed are now suing the university that killer attended. This lawsuit accuses Washington State University of failing to act on warning signs about the killer's behavior and their inaction that they say contributed to the stabbings. The suit claims that this WSU graduate, and he was also a student and teaching assistant, that other people had actually reported him for stalking and inappropriate conduct with women, but the university didn't take any meaningful action. CK, I'm going to start with you on this one. 25 seconds to state your case on a lawsuit against a university. I know you handle a lot of big lawsuits. What about one against a university that employed a man who did something no one could have imagined?
Well, my case would be, even though no one could have imagined it, I'd link it. I'd say people reported him. They knew he was, they had a duty to investigate. Obviously, they didn't do a good job of investigating because there was more than one person that reported him. They had a duty to do something. At a minimum, remove him, put him on watch, do something more than they did. And as a result, and there could be a causation issue, but as a direct result of the university not doing what they should have done, this is what happened. That's in the civil world. You got to tie it.
Let's move to Marie. What's your take?
I don't think that the connection is there. I don't think there was a duty of care. I would have to know, what did they report him for? Remember, he ended up murdering those people, stabbing them back to back in their homes. Did he ever do anything violent in the school that went unreported? Or was he just that quirky, autistic, you know, strange person, right? Is that what it was? They had to show, before they can be sued for not doing what's right and getting him off the street, that he was a danger over there.
All right, that's the time. Let's move to Bob Bianchi, because Marie makes a point, Bob, that you have to make this connection and know what's the line. How much of an advance notice would this university have to get, and how serious would all of those details have to be?
I'm with Marie, and I think a little bit with CK, too. I think that look, it's a terrible tragedy. There's no question about that, but that's not what a civil suit is. In order to be held responsible here, you have to show causation, but for this, then that, and you have to show foreseeability. And I don't think anything like this is going to be foreseeable. In fact, I think it's quite to the contrary. It's a crazy, wild, outside the spectrum that anybody could have possibly thought that this would have been the result, even if they knew about some of his errant conduct. I don't see it.
Well, we've got a lawsuit that is pending. We'll continue to follow what happens there. Such a tragedy all around, though, for these families. Let's move to our third story. This one, the headline is, in New York, President Trump won't pardon Sean Diddy Combs. That's according to New York Daily News. In an interview, the president said that the hip-hop mogul sent him a handwritten letter seeking a pardon, but after reading it, he decided against it. In December, lawyers for Combs urged a federal appeals court to order his immediate release from prison and to reverse that conviction that he got on those prostitution-related charges, or direct his trial judge to lighten his 4-year sentence. Now, of course, he got acquitted on sex trafficking, on RICO, all of the major charges against him, but prostitution did remain, and the judge gave him something that was close to the max. Let's get our Court of Opinion panel's take on that. CK, I'll start with you. What's your opinion on the president turning down that pardon request?
Really? Really? So, very quickly, prostitution charges. We can't talk about what he didn't get convicted on. Well, a number of people, about a year, got pardoned for the activities of January 6th. Some of them were convicted of, there were 5 people that died. So all I can say, really, I'm not saying any of them should have been pardoned.
That's the time. Marie.
I think Sean Diddy Combs needs to just do his time. I think it was low, petty, and pathetic that he wrote a letter. Why can't he just do the time? It's almost like he got away with everything. What is the rest of the time that he has to do? Take it like a man, do it, and get out and go on with your life. Why are you writing Donald Trump asking him for mercy like he was going to give it to you? Maybe if when Donald Trump was running for president and he knew what was coming, Diddy, if he stood behind him and was that one black person, maybe he would have gotten it.
We got to get to Bob on this one. And Bob, keeping in mind that he did ask for this pardon and the 4-year sentence is out there, and it is a lengthy sentence for some people when it comes to a prostitution charge. You are the former prosecutor, head of the homicide division where you were. Let me hear your take on whether or not he should have gotten a pardon or if that 4-year sentence is simply too long.
Ladies, I'm going back to civics class. Our founding fathers put the pardon power into the Constitution because of their fear of government excess and overzealous prosecution. However, the power is absolute and solely within the discretion of the president. Some are more liberal, some are more conservative. This guy violated the #1 rule with this particular president, which is you didn't speak kindly about him and were antagonistic to him, and that is going to be
exactly
a denial.
Bob Bianchi, Marie Pereira,
Exactly.
CK Hoffler, that is where we have to leave it. You all delivered some fiery opinions today. We appreciate it. We have to leave it there, but thank you for connecting with us this hour. I'm Julia Jenaé for Court of Opinion, reminding you to strive to respect the other's opinion, even when we don't agree.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.